Ladies and gentlemen, Supreme Court, Trump's immunity case goes back to lower court. This, ladies and gentlemen, completely ends any attempt, and hit subscribe to this channel right now, at indicting Trump yet again. So they tried to indict Trump again for what they felt or viewed were unofficial acts. The problem, however, is that I'll read you this. This is PBS. The Supreme Court extended the delay in the Washington criminal case against Trump on charges he plotted to overturn his presidential election loss, all but ending prospects the former president could be tried before November. It ain't happening before November. So number one, the lower courts still have to decide what is official and unofficial, even after the new indictment. Number two, it then has to go back, potentially, likely, to the Supreme Court. None of this is going to happen before November. So Trump has already won from the Supreme Court ruling. An historic 6-3 ruling, the justices said for the first time that former presidents have absolute immunity from prosecution for their official acts, no immunity for unofficial acts. But rather than do it themselves, the justices ordered lower courts to decide precisely how to apply the decision to Trump's case. So a lower court has not looked at the new indictment. This is going to take months, potentially years. When Trump wins, he overturns the Supreme Court. He overturns the special counsel. Hit subscribe. Your super chat is very important. Ladies and gentlemen, we're at almost 265,000 subs. Literally like 2 or 3 away. You could be the 265th sub on this channel. We'll get to the Supreme Court ruling continuing to protect and shield President Trump from unconstitutional efforts to imprison him right before November. Gee, the people who worry so much about democracy want to imprison their direct political rivals. Hit subscribe right now. I'll explain a lot more in a second.
So this Fox News alert now, we have major breaking news on one of the cases facing the former president, Donald Trump. Specifically, the documents case based out of Palm Beach, Florida. For more on that, David Spun tracking it in Washington, D.C. And David, I'll allow you to deliver this major headline.
Judge Eileen Cannon has dismissed the classified documents case against Donald Trump in Florida. This is massive news. We did not see this coming at all. This is a case that she tentatively postponed to a later date. The original trial was set for the end of May. She moved it back a couple of months, though not setting a date. She has just dismissed it in a 93-page court document saying that Jack Smith, the special counsel's appointment, violates the appropriations clause and the appointments clause of the United States Constitution. In layman's terms, she's saying that he was not appointed lawfully and not appointed appropriately. I'm sure
So not only do you have the Supreme Court of the United States of America saying, yeah, Trump is protected for official acts, and you have not decided you have not explained to the country what is an official and unofficial act, so they just redid the indictment today in a desperate attempt at trying to imprison Trump. Why would they have to redo the indictment? Well, because initially it was unconstitutional. And they're going to have to send it back to a lower court, and then likely the Supreme Court back again to decide, again, what is constitutional, what is unconstitutional. But the special counsel itself is not constitutional, according to the Florida judge. So that's another issue. So the documents case was just completely thrown out, which also is precedent for the indictment that was rewritten today to be thrown out as well.
We're going to be hearing from the Department of Justice about this momentarily, as Attorney General Merrick Garland believes that he had every right, and his team believes every right, that he could appoint Jack Smith as special counsel. We're going through this right now. It's 93 pages. The printer is cranking up behind me, page by page. But essentially, the bottom line here is that this documents case goes completely away for Donald Trump. There was a hearing that was originally scheduled for next week to talk more about this appointments issue. Judge Cannon issues this on the day of the beginning of the RNC. So right now, Donald Trump still has one pending case against him in federal court. That's here in Washington, D.C. That's his alleged attempts to try to overturn the 2020 election. Special counsel Jack.
And the issue was that it was such a broad and vague and ambiguous indictment. You could have indicted this. You could have indicted Democrats for utilizing faulty intelligence that said Trump was an operative of the Kremlin, or could have been. They used the 18 U.S. Code 371 statute. So everyone who purchased the Steele dossier, which, by the way, led to an FEC fine because campaign funds were used to purchase that, deceived the country. How many times have Democrats deceived the country to go after Trump? Well, the entire Mueller probe was based on deception. There was not a shred of evidence that Trump ever committed any crime with the Kremlin. Say that a million times. Okay? And they kept saying, remember when Schiff and others said, well, we have something in between evidence and circumstantial and direct evidence, and they had no evidence. They had nothing. But they created a new Cold War. And McCarthy era Red Scare. Why did they do this? It was a deceptive move. They deceived the country. That's what they are accusing Trump of doing, deceiving the country. You want to indict people for deceiving the country? You can indict a whole bunch of Democratic politicians for doing so, and also journalists as well.
Jack Smith received a blow to that case just a couple.
If you can prove malice for the journalists.
Weeks ago with the Supreme Court, that seems to be somewhat delayed right now. But this is big news. No question that this case is completely dismissed. Bill?
What's interesting is that, David, you said that's a 93-page ruling. I'm kind of curious as to why it would take so many pages, because if based on what you're saying is she's not ruling on the merits of the case. She's ruling that the special counsel should never have been appointed.
Numerous attorney generals, I believe, even one from Reagan's administration, wrote on behalf of Trump's legal team stating it was unconstitutional. See, Colorado ban, unconstitutional, overturned unanimously by the Supreme Court. Indictment pertaining to Trump's official acts, yeah, unconstitutional. Now we find, and so he got an immunity victory. And now we have another victory for Trump with the documents case. Unconstitutional appointment of the special counsel. Today, we had another attempt to indict Trump, but it's not going to lead to anything. The indictment has to go through the same process again. They're indicting Trump not for a specific crime. That's the point. They're indicting Trump for speaking to Department of Justice officials. So what? They're indicting Trump for a speech. So, and yeah, a president can perform a speech. He can speak to DOJ officials. Then they say, not if he's trying to commit a crime. You are then indicting and convicting future and past presidents. The lead up to sending Americans to never-ending military conflict, George W. Bush, Cheney, Rumsfeld could have all been indicted under that statute or under that mentality. President Obama could have been indicted for the intervention in Libya. A great many presidents, and like every other future president, if they say something that you could say was deceitful in any way, you could indict them. And they still haven't proved without a shadow of a doubt that anything Trump said was deceitful. But that's a whole other story.
And then I wonder about the how that will reverberate throughout the Department of Justice, because does that mean that other situations like this would also be dismissed?
It's a great question, and we're waiting to get some clarity from DOJ. I'm just reading here on page 2 of 93. It says the Appointments Clause sets as a default rule that all officers of the United States, whether inferior or principal, must be appointed by the President and confirmed by the Senate. Jack Smith was not confirmed by the Senate. I assume Dana and Bill will hear an argument from DOJ that past special counsels, John Durham, Robert Mueller, just to name a few in recent memory, also were not confirmed in that way and were appointed and were allowed to continue their work. So that's what we're probably going to hear from DOJ. But a major coup and major win for former President Trump, who comes off this last weekend.
I'm Steve Doocy.
I'm Brian.
Jonathan Turley, Fox News contributor, George Washington University law professor and constitutional law attorney, and Andrew Cherkasky.
So all of these victories lead to the reality that they cannot imprison Trump. Okay, well, here's the thing. There's like a 2% chance, 5%, that he actually steps foot in prison. The reality is that no matter what, the prison sentence or jail sentence is going to be overturned. Just like the indictment that was unconstitutional, just like the special counsel that was appointed in an unconstitutional manner, Trump was convicted in New York in an unconstitutional way. The FEC was not involved. The federal government was not involved. Yet the state stated Trump committed a federal crime. They had to say that because he only committed misdemeanors in New York. They elevated the misdemeanors to felonies, utilizing an imaginary federal crime. This is going to go directly to the Supreme Court when it gets, if Democrats dare, let's just say, if there's even a chance that he actually steps foot on September 18th, which is like a 5% chance that they make him go to jail, then you're going to have the Supreme Court immediately overturn the conviction and jail sentence. We'll get to that in a second because of all of this. Listen to this.
Former federal prosecutor, welcome to you both. Jonathan, I'll get your top-line thoughts here as this news breaks. I want to read you directly from Justice Sotomayor's, from her decision, her dissent, along with Jackson and Kagan in this case, that if a president, quote, orders the Navy's SEAL Team 6 to assess.
See, here's the thing. The Democrats and pundits and even the Supreme Court justice have stated something that is completely, that has nothing to do with Trump's argument. The legal team stated that Trump is immune from federal prosecution for official acts as president. To order the ending of someone's life is an unofficial act. You could not do that normally. You would have to actually convey in some manner that you wanted your political opponent. And it's interesting because Trump survived that on his life. But anyway, that's another story. It's interesting how everything Trump's political opponents are so concerned about, Trump has to live through. And he has to experience in terms of first-person experiences and events. But anyway, speaking in an algorithmically friendly manner. But anyway, it is not an official act to order the ending of another opponent's life. Just because the Supreme Court found that what Democrats were doing in Colorado, for example, was unconstitutional, banning him from the ballot, or in D.C. trying to get him on a speech, that doesn't mean that he now has the freedom to do anything he wants. That's the very grandiose, apoplectic leap of logic. Oh my God, we can't indict him on a deceptive speech, which, by the way, still hasn't been proven to be completely deceptive. Democrats are trying to imprison Trump because he had doubts that Biden defeated him fairly. Literally, he's not even up against Biden anymore. Even the Democrats didn't want him at the end of the day, and now he's going up against Harris. But they're still trying to state that everything he's saying was completely false, and he knew it was false. So that's a very broad, vague, ambiguous legal statute, the 18 U.S. Code 371 statute, that you could use against, like I said, anyone that accused Trump of being an operative of the Kremlin. He wasn't. There was no evidence that he was to begin with. And so who was deceiving the country? That's what the statute says, if you deceive the country. You could literally do that against President Obama's presidency, Bush's presidency. You can indict those two former presidents right then and there.
Assassinated a political rival, immune. Organizes a military coup to hold on to power, immune.
These are not official acts, so how on earth could this be viewed as an official act? He didn't stop anything that day. He had nothing to do with the criminality that day. Zero to do with it. He had a speech and then he left. And he said to people to go peacefully and patriotically. They didn't listen to him. And then, of course, there are other issues pertaining to that day. People were let into the building. We know from footage that exonerated numerous individuals. So it's like the people, it's an actual cult. Like, if you don't know anything about politics and you don't know anything about the law and you're just so wrapped up in this bubble, they say that Trump supporters are a cult. No, I wouldn't vote for any other Republican. I'm not going to vote for, a Republican no matter what. Like a house cat or a fern, if you put like an R next to the... I wouldn't vote for any Republican. The cult is if you're just going to do anything at all times the same way with the same paradigm of thought, despite how illogical or irrational it is. So it's Democrats who literally chose somebody who couldn't communicate, then jettisoned the person, then got as vice president, and still going the same direction. She's trying to hide from media and doesn't want to, discuss her plans as well. And then they're calling Trump supporters a cult. It's like, no. The definition is embodied by those who are supporting Harris right now.
Takes a bribe in exchange for a pardon, immune. Were her words in her dissent. Your reaction at this hour?
Well, I think the problem with the dissent is that it doesn't show the same vigor in looking at the opposing view. President Obama ordered the killing of an American citizen by simply declaring him to be a terrorist without a trial. Clearly, Justice Sotomayor does not appear alarmed about that, and presumably would view that within a core function. So what the majority was trying to do here is to find something in the middle. They did not embrace the Trump sweeping arguments. They did not embrace the lower court's arguments sweeping in the other direction. But this is a major victory for the former President Trump. The language here is highly favorable to him. They even go into his January 6th speech and say that presidents are expected to speak passionately and publicly about issues of importance. This was an issue of great importance, and goes on to say that when the president speaks to the vice president, this is part of the president's official conduct. All of these statements are important because the court is giving navigational beacons for a lower court judge who is proven very favorable towards the special counsel, very motivated in getting a trial before the election. And these beacons are a bit more narrow than we expected. They're giving some very clear language and a heavy burden for Jack Smith. Now, he's not likely to go quietly into that night, but he's going to have a heck of a time trying to satisfy this burden.
Jonathan, thank you for that. Andrew Cherkasky's on set here. Jonathan, you just heard from Jonathan, you heard from Shannon. This is being seen as a major win, not only for the former president himself, but for the Trump campaign. And the timing of all of this obviously is crucial. Your reaction?
I think this totally guts Jack Smith's prosecution. And it's something that some of us have seen for a very long time coming. The idea that a president doesn't have this broad sweeping immunity would create all sorts of issues for presidents in the future and potentially in the past for acts that have been committed in the past. Now, what the court has done is they've essentially created a hierarchy. Those acts that are within the constitutional authority of the president, immune. Those that are official, those perhaps have to go back to lower courts for further analysis. And the court does say unofficial acts have no immunity to it. But I think what we have to look at is that middle category. And it really does break down the
What Democrats did was they went after Trump using the most broad and vague and ambiguous legal statute that you could use against President Obama or Bush or any other former president. They said, well, he knew he was deceiving the country. No, he didn't. He believes everything he said. And guess what? I would say most Republicans and nowadays most Americans likely believe. What was Trump saying? Essentially, Trump was saying, I can't believe I lost to this person he can't even communicate. Okay, Democrats jettisoned and ousted the current president from the presidential contest after he had won his primary. That bolsters everything Trump was saying that day. I mean, the foundation of the indictment is how dare you try to delegitimize this legitimate and wonderful process. 4 years later, Democrats jettisoned the man who defeated Trump, completely undermining the indictment against him.
The idea that at least two of the remaining charges, and last week's case in Fisher likely will eliminate 2 out of the 4 of the charges against Donald Trump right now. So really, they have kind of 2 charges left. I think Jack Smith is going to have to go through, probably create a superseding indictment, send that back to the court for their new analysis under this new standard.
So the indictment has to go back to the lower court, and then we'll go back to the Supreme Court.
That may go all the way back through the appellate courts, even up to the Supreme Court, to see if the lower court analyzed that correctly before we're ever talking about a trial. So I think that even the idea that this could make it to trial with the little bit that remains, I don't think is likely, because I think this is going to go all the way back through the appellate system.
Jonathan, give me your reaction to that. And also, I want to highlight something you put out in the moments following this on the no protection for unofficial acts. So the issue is whether or what constitutes official acts. It is very much for Trump in the sense that the court rejected the lower court and recognizes some immunity. That will further delay the lower court proceedings, to Andrew's point, but Trump will have to argue that his actions fall within these navigational beacons. How do you see that playing out specifically?
Well, I think that this goes back with a heavy advantage for Trump on those questions because of the language used by the court. It is clearly telegraphing that there is a heavy presumption here, not just in terms of the general constitutional standard, but this specific case. Many people expected the court to avoid the specifics in the case. It did not. And it left language to guide this court. Now, in terms of how this plays out, even with a judge who's been quite favorable to the special counsel, it's going to be difficult to satisfy this burden, particularly with regard to things like the January 6th speech, which the special counsel has referred to a great deal. Many of us believe that President Trump was protected entirely in that speech under the First Amendment. The court is saying here that he also may be protected as a point of presidential duties, that it's expected for presidents to be able to.
So let's listen to that again. Very important.
Speak on these January 6th speech, which the special counsel has referred to a great deal. Many of us believe that President Trump was protected entirely in that speech under the First Amendment. The court is saying here that he also may be protected as a point of presidential duties.
How many speeches were given by Biden, by Harris, by Democrats alluding to Trump working for the Kremlin or being a toy or whatever puppet of a certain adversarial leader? Okay. How much of that was a lie and deceitful? They knew very well he wasn't. They just kept on bringing up the same Cold War nonsense. It was all deceitful. The Mueller probe showed that Trump had 0 ties. They say ties. Democrats have more ties to that country. You can look at the uranium sale during President Obama's administration, and you say only President Obama could have vetoed the sale. Even Snopes agrees that only president. Well, why didn't he veto the sale? Well, maybe it has something to do with the money that the foundation got. Anyway, the point is, there was a New York Times article doing great investigative journalism when the New York Times took a moment here and there to investigate Democrats, talking about how the Kremlin was happy that they were able to do that during Obama's administration. Okay, so Trump didn't do that during his administration. Okay, he also kept sanctions on a pipeline in that region that, of course, Biden removed. All of these things took place. Okay, they impeached him on weapons armament shipments that actually he eventually gave, more so than his predecessor, but we can go on forever. Everybody who said that Trump was working with the Kremlin based on intelligence, so does that mean they were all indicted they should all be indicted and imprisoned for lying to the country? I mean, it's like the same, it's literally the same statute. The statute is the 18 U.S. Code 371 statute, if you deceive the country. So have Democrats deceived the country pertaining to Trump? Of course they have. Should they be indicted now based on the special counsel logic? Well, of course media would say, no way. Democrats would say, no, we don't lie. Only Trump lies.
That it's expected for presidents to be able to speak on these types of issues. So going forward, it's going to get tough because Jack Smith is known as someone who tends to double down on weak hands. I mean, he's not someone that yields readily to a president. That's why he was unanimously overturned in a previous high-profile case. So he's just, what's interesting about this case is that this is following a haymaker in Fisher, which could knock out 2 of the 4 counts in D.C., but not necessarily. Justice Jackson gave him a roadmap of how he might still be able to argue obstruction. I wrote a column today saying that if he follows Judge Jackson's advice, I think he will be overturned again. But he may still try to keep this on the runway.
I'm looking at the original indictments now. There's 2 charges under the 18 U.S. Code 371, conspiring to defraud the United States. Do you think Democrats have done that in their attempt to paint Trump as an operative of an adversarial country? Of course. The Mueller probe proved that. He wasn't indicted on conspiring with another country. That's what they accused him of doing. They knew it was nonsense. Then 2 charges regarding obstruction of an official proceeding. He didn't know that the official proceeding would be obstructed by anything he did. What did he do to obstruct an official proceeding? He performed a speech. He never said, go obstruct this proceeding. Go. How many proceedings have Democrats obstructed with protests? And the Supreme Court actually used that to prove how nonsensical the indictment was. Then it was conspiring to deprive people of their rights as they literally disenfranchised their own voting base, their own electorate, their own constituents, by removing mashed potato brains from the primary and then handing his delegates to Harris. I mean, the Democrats are indicting Trump on depriving the rights of Americans who wanted Biden, as they literally deprive the rights of Americans who wanted Biden and then give all of his delegates to Harris. Only the Democratic Party of today could do all of this.
Take off. I personally think that these 2 opinions have ripped the wings off his case. But Jack Smith is someone who does not readily yield to these types of setbacks.
I'm Steve Ducey.
I'm Brian Kilmeade.
And I'm
And this is, ladies and gentlemen, a brilliant explanation of, I think, what the Supreme Court has already agreed to. So the sentencing is about September 18th, the middle of this month, and This is all the Supreme Court needs to overturn the jail sentence.
Is far more extraordinary than anything Donald Trump and his lawyers would be asking the Supreme Court to do. Why? These are federal law, federal constitutional violations, federal jurisdictional violations by an acting state judge and a prosecutor, by two people. And it's ongoing. Sentencing and other issues have to be decided by the local judge, and then the appellate level, and then the level after that.
So Mark Levin is explaining how unconstitutional the conviction was in New York and how it can easily be overturned.
This is an ongoing violation. It doesn't even matter what the final court has to say. Again, if I'm Donald Trump's lawyers, I go through that process, but you go to the Supreme Court of the United States. Now, how do we get to the Supreme Court of the United States? This is where people get bogged down. There are writs at common law. And it really doesn't matter which writ you follow. Here's a piece by former Attorney General Griffin Bell. He would later become Attorney General under Jimmy Carter. In the Southern Methodist University Law School Law Review, the federal appellate courts and all writs. And it discusses what these common law writs are. Now, it discusses it in the context of a specific statute, the All Writs Act, that was passed as part of the original Judiciary Act in 1789. Not to get into the weeds, we're smart, we can follow this. The peremptory common law writs are among the most potent weapons in the judicial arsenal. These common law writs are used. They're rare, but they're used more and more within the federal chain of courts.
Hello, everyone.
Does he say here? Well, the basis for general judicial supervision over inferior federal courts, through extraordinary or preemptory writs can be found in early common law. The All Writs Act is a direct descendant of the Judiciary Act of 1789, other than the Supreme Court, which is created by the Constitution. Everything else is created by Congress. All the other courts, the number of courts.
To reiterate, he's only been indicted again because the Supreme Court obliterated the initial indictments. Now they have to do the same process over again, which will take years, long after November. The point, however, is that the Supreme Court victories that he received regarding immunity, regarding the Colorado decision that overturned the Colorado ban, the Supreme Court decision in Florida, the Florida court decision tossing out the documents case because of an unconstitutional special counsel. All of this helps with Trump in New York. The big issue is the immunity case and the fact that he's protected under the Constitution. Speaking to an attorney, for example, whether it's Michael Cohen or any attorney, he, number one, has attorney-client privilege. Number two, he's protected because it's an official act as president. Number three, the FEC, former FEC chairman, the FEC did not indict Trump, was not part of the process. The Department of Justice wasn't a part of the process. The federal government wasn't part of the process. The state cannot convict Trump of a federal crime without the federal government being involved. It's blatantly unconstitutional. The immunity case is one of the reasons the Supreme Court will protect Trump, has essentially already overturned the jail sentence and conviction. It's just a matter now whether Trump has, there's like a 5% chance that he does step foot in Rikers, which it's funny, Democrats care so much about norms and traditions, they've done away with any semblance of norms and traditions. every time the Supreme Court says they've done something unconstitutional, instead of looking in the mirror and say, oh, wow, we did something unconstitutional against Trump in this maniacal effort to gut him, it's, oh, my God, the Supreme Court should be, abolished. There's such mania regarding getting Trump that they don't realize that even the Supreme Court has stated what they're doing is unconstitutional. So, the verdict in New York was unconstitutional as well. This is just a string of major Supreme Court victories that he gets. The Supreme Court has essentially already ruled that it's unconstitutional because there's already precedent on rulings that separate state from federal prosecutions. There's no jurisdiction here, and he gets to that.
How many justices are on the Supreme Court? It granted federal courts the power to issue extraordinary writs in aid of their respective jurisdictions. And while it is clear that the All Writs Act authorizes the issuance of the traditional common law writs of mandamus and prohibitions, the phrase all writs also encompasses common law certiorari, injunctions, subpoenas. Don't worry about all that. What that really means is there's many ways of characterizing this direct appeal to the Supreme Court and relaying the facts and relaying what's taken place under the law to the court. In fact, you can use multiple requests for writs. It says choosing the correct writ to obtain the desired relief is no longer necessary in the federal courts. Different writs may be sought alternatively or cumulatively. The choice is now unimportant. The subtle distinctions among the various writs have no effect on their relative usefulness as vehicles for interlocutory review. We're not seeking interlocutory review at the federal level, but in effect we are of the state court's activities. Hello, before you finish on the state side, we have some big questions that the Supreme Court needs to answer. The jurisdictional prerequisite for application of the All Writs Act is simply that the writ be necessary, appropriate, in aid of the jurisdiction of the issuing court. The Supreme Court in Labai versus House-Letper Company explained the power of the courts of appeals under the Act. Quote, the question of naked power has long been settled by this court. Since the Court of Appeals could at some stage of the proceedings entertain appeals in these cases, it is power in proper circumstances to issue writs of mandamus reaching them. This is an expression of prospective or concurrent appellate jurisdiction. The power of the courts of appeals to issue writs is not limited to cases where an appeal has already been filed. Rather, this power of review extends to all proceedings where the actions of the trial judge at some future stage of the litigation may be reviewable. That applies to the federal chain. But as I explained here, we have violations of federal law, of federal constitutional provisions by a state court. Now, does the Supreme Court?
The state court in New York violated constitutional law by convicting Trump on a federal crime. They had no right to do that at all. They had zero right to convict Trump of a federal crime. Why? Because the federal government did not indict Trump. If the state uses a federal indictment against Trump, they can do that. But it has to come from the DOJ. It didn't even come from the DOJ. Why? Because Biden's administration knew he didn't commit an FEC crime. They knew that the FEC would then be involved and would then say, yeah, we actually ruled on this and we dropped the hush money case. So they got away with that by the DOJ not getting involved, the state convicting Trump. This way, the Supreme Court would then be forced again to get involved and untangle Trump from this mess that Democrats created.
Does the federal government ever get involved in state court decisions or state law decisions or state regulatory decisions? You better believe it. There are things called express federal preemption, which is what we have here. Federal Constitution, federal due process rights, federal equal protection rights under the Constitution as applies to the states. Federal jurisdiction under the federal election law, under a federal presidential election, and I could go on and on and on. You have implied federal preemption. You have states that are obstructing federal preemption. You have all this litigation of precedential activity that's taken place before that gives the Supreme Court jurisdiction. A state cannot regulate Congress, which is what it's doing in that court when it takes over authority for determining what a federal election violation is.
A state like Mark Levin states cannot determine what a federal election crime is. End of story. It's so blatantly unconstitutional. It's even more unconstitutional than the Colorado ban, which was unanimously 9-0 reversed.
That's important. Or the Equal Protection Clause, or the Due Process Clause, or the First Amendment Free Speech Clause about a non-disclosure agreement. Federal courts, starting with the Supreme Court, have intervened in state actions before. Civil rights issues, death penalty issues, Bush versus Gore, a presidential election issue, where you have federal jurisdiction issues. And how have they used it? Well, the Supremacy Clause, they've used the Commerce Clause, they've used the Necessary and Proper Clause. When it comes to regulating federal elections, especially a presidential election, Congress has exclusive plenary power. And the Supreme Court has overall authority. When you have an extraordinary, radical, extreme, multitudinous case of violations of federal law, whether it's substantive, whether it's process, whether it's jurisdiction, this is the case. Me, as I said first out of the gate, I'd file common law writs. I'd file a writ of prohibition that restrains a body exercising public power from exceeding its powers or usurping jurisdiction, which it does not have. It seems like this. You could file a writ of mandamus, ordering a lower court, in this case the state courts, to stay their actions while the court considers it. It might go with a writ of certiorari, arguing that there is a statutory basis for it. It doesn't matter. You've got to take it to the door of the Supreme Court. They will decide whether to take it or not. And if
so, Trump's legal team they've already petitioned the Supreme Court. They've utilized the correct manner, procedure, writ, protocol. Now it's just a matter of the Supreme Court not getting involved until the last second. So either before Rikers or after Rikers, or before the possibility of Rikers Island or jail, you're going to have the Supreme Court get involved, okay? Because the immunity case, that's already done. That's already going back to a lower court, but that affects the state prosecution as well. In addition to the state, the hush money prosecution not being constitutional, being unconstitutional, because you can't have a state decide on a federal crime, and the federal government and FEC were not involved. They dropped the hush money case. The state has no right to then revive it and say that Trump committed a crime when he didn't. Because FEC chairman stated Trump could have paid Stormy with dollar bills. It would have been fine. But you have the issue of they want to actually sentence Trump. They're going to September 18th. If they postpone the sentence, we have nothing to worry about. Because when he becomes president, then the Supreme Court has all the time in the world, and then they've already ruled that there is a separation between state and federal indictments, and the state cannot just unilaterally decide on a federal indictment without the federal government involved. John Yoo, on Mark Levin, stated that there were numerous precedents backing that. But now it's September 10th. We have the debate. Then we have September 18th. We have Trump, the sentencing, which, like I've explained, it's the Supreme Court will get involved. There's a 5% chance he actually goes to jail, but 95% chance the Supreme Court before that takes place gets involved, or 100% after that takes place gets involved. And then Trump wins in November. So, and he wins in large part also because the economy is, stinks. And we had September and October, we have to watch for a stock market collapse, a complete financial stock market collapse. This is why, ladies and gentlemen.
The Kroger-Albertsons merger goes on trial today. The Federal Trade Commission wants to block it. They claim it would eliminate competition and raise food prices even more. Stephen Moore is with us this morning. Steve, I think this is the Democrats' anti-business stand on full display. If it's big, it's bad, except for government power. What do you say to that?
Yeah, I couldn't agree more, Stuart. You look at the antitrust actions that have been taken by Lena Khan and the Biden administration. They've never seen.
Hold on 1 second.
Let's bring in Strategas Chairman and CEO, my friend Jason Trenner. Jason, terrific to see you. Kamala Harris is the incumbent. She is not the insurgent. And in the last 3.5 years, she dramatically helped raise taxes on every working man and woman in this country because of inflation and much higher prices, and created an affordability crisis for anybody who wanted to buy a home. But how do you see the overall plan that she's laid out? It's, in your words, central planning.
It's central planning, and I can't see how this is more liberal, this is more progressive than the Biden-Harris administration, what you've seen so far. And none of the things that Mr. Waltz was just talking about would bring down the most hidden and insidious tax, which is inflation. It would increase inflation because we'd be spending more money. We are running budget deficits right now that are about 7% of GDP. We've never done that when we haven't been in war or when the unemployed or in recession. We're spending money like it's going out of style. There's no coordination between the Fed and fiscal policy, and inflation will get worse given these policies that she's talking about. It is beyond me. You can say the words, but it doesn't make it true.
You pointed out recently that Harris and Biden have started handing out money through this COVID era program, the Employee Retention Tax Credit, where it was 95% of the claims for it were fraudulent. But they've actually started handing out billions of dollars in this program to try and juice the economy and literally buy votes before November, Jason.
Listen, Dagan, all presidents in the fourth year incumbents try to grease the skids for their own reelection. Biden and Harris have taken this to an art form that I have never seen before. The Employee Retention Tax Credit, we're talking about COVID relief, and COVID ended about 3 years ago. $5 billion will be sent out in early September, another $20 billion, so $25 billion total by the end of the year. Add that to $170 billion in student loan forgiveness, if you could call it that. Mm-hmm. Add to that a strategic petroleum reserve that is at its lowest level since 1983. And then add to that as well the budget deficits that we've been talking about before. This is all adding up to essentially, as you said, trying to buy people's votes. But it may lead to some temporary relief, but it will lead to long-term pain, and it will not relieve people of, as I said, the most insidious tax of all, which is inflation, which hurts the poor and working classes more than it does wealthy people. This is a very regressive economic policy that you're seeing from Harris and Biden.
Right, and that's why personally it pisses me off so much that they can't acknowledge even 1 ounce of the pain that they've caused for so many working Americans. So we found out this week that we're going to hit $36 trillion in debt for the nation by the end of this year. But Elizabeth Warren says she's in favor of Kamala Harris's economic policies because the bill has been settled.
How has the bill been settled?
I feel really good about what she's put out. So start with price gouging.
This is why I left that political side, okay? I was the biggest Bernie Sanders booster on the internet, according to the Huffington Post. I was the unofficial scribe of Sanders' most hardcore voters, according to the Washington Post. Why did I become a supporter of President Trump? Because we had record low poverty. In 2019, Elizabeth Warren knows this almost certainly. We had record low poverty, low inflation, low interest rates. You could buy a home with 3% interest rates in 2018 and 2019. Now the interest rates are closer to 7% for mortgage rates. And we didn't have, and real wages were up. Elizabeth Warren knows real wages were down most of Biden's tenure. And she knows that interest rates are high, which is why inflation is a lot less than the 9% it hit in 2022. So this is why, and we had record highs in household median income under Trump. So why would I not want Trump? If you're on the left, you care about the working class. Objectively, the working class did better under Trump. Objectively, by every measure. We had record low poverty. And then you want to say, well, we had low poverty with Biden. There's a difference between record low poverty in a functioning economy where you're not just writing stimulus checks after preventing people from working. So you have Elizabeth Warren and Bernie Sanders. These people, it's like a racket. They pretend to care about the economy. But she knows very well we're on the brink of a stock market collapse.
You know, we have a problem that prices are just too high for families.
What space is left for a potential Harris administration to spend billions or trillions more on the kind of policies that she's promoting?
Ooh, now,
without compounding inflationary pressure. How does she do that responsibly?
All those things you talked about, I just want to remind everybody, were paid for. The last big expense that wasn't paid for was the Donald Trump tax.
The Trump tax cuts Democrats have still kept. She knows that we still have the Trump tax cuts. She's bringing that up, but she's not telling you that Democrats did not do away with them. Why not? Why didn't Democrats repeal the Trump tax cuts? They still kept them. Why? Because they worked. They did spur economic growth. We had economic growth with low inflation and low interest rates. They worked. And we had record low poverty in 2019 before Democrats shut down economic activity. And that was a choice. Nobody forced them to do anything.
Cuts.
Jason, your response to that one.
Yeah, I don't know what the hell she's talking about. If it's paid for, why does the the amount of debt continue to increase? Why are we running budget deficits of $2 trillion a year? Not only that, we are funding our debt short term as opposed to longer term, which means that interest expenses right now exceed our defense budget. By next year, our interest expenses will exceed our Medicare expenditures. So paid for, I don't know what she's talking about. If it was paid for, we wouldn't be accruing all of these new debts every year, day in and day out. It's mystifying. Again, it's frankly, it's just a lie.
Yes, it is a lie. But I do love, Jason, before we go, how Elizabeth Warren was giving huzzas to the price control plan, which the Kamala Harris team denies as price controls, because Elizabeth Warren and Kamala Harris in 2020 proposed a price control plan. And it is very much that, and it's not just for groceries. It's for a range of industries across the United States where the Federal Trade Commission would decide what is excessive pricing.
And then you'd run out. Elizabeth Warren would control prices, or would want to control prices. And then, of course, we'd run out of basic items because there's no economist that's ever lived or ever will live smart enough to decide the price of mayonnaise or ketchup or bread or eggs or meat or oil. That's why you have a market that decides the price of these things. Anyway, hit subscribe to this channel, ladies and gentlemen. The Supreme Court's going to overturn the jail sentence, the sentencing, the conviction. It's just a matter of when. That's all. It's just a matter of when, either before or after September 18th. Hit subscribe to this channel. He'll win on November 5th. September and October are going to be very interesting. I think that Trump, it's going to be very interesting for Trump. He'll continue to have these victories. I don't think anything's stopping Trump from winning in 2024. In November. Hit subscribe. Thanks, everybody. I'll see you tomorrow.